Lincoln, I want to ask you a question about litigation costs because this comes up all the time. Um, Client is involved in a dispute. They potentially want to take this person to court, or they're getting sued. And the first question they're going to ask me before they say, talk to an attorney is, how much is this going to cost? I have no idea how much it's going to cost. Go talk to a litigator. So I'm sure you get hit with this question, right? Somebody comes to you, says, hey, I want to sue this person. What is it going to cost? How do you go about even trying to estimate something like that?
So first off, it's always going to be difficult to estimate because litigation is very it's very unpredictable, like I said earlier, right? But I would say the best way to go about it is to create a budget analysis based on different plans and different phases of the litigation, right? Perhaps your initial plan is, okay, well, it's going to cost this much to send out demand letter. Let's see what happens when they come back, and then we can reassess. Perhaps that's the initial phase. Or maybe your plan is to send out a demand letter and then go to mediation early on to get the case settled. Perhaps that can limit your damages. Or if there's an arbitration provision, you would have a better understanding. Perhaps like maybe a year or so, you're going to get a judgment on this case, and you can kind of limit your exposure in that sense. It's just based on. You have to have contingencies in place, and you have to make decisions based on what you know at the time. And then when you find out more, you can reconvene, and then you can reassess at that
point. A lot of times in talking with clients too, in terms of the budget too, is at some point you either have a choice to escalate or de-escalate the situation. And if you're going to take the aggressive approach and say you're going to escalate, you could trap yourself in a lawsuit. Mm-hmm. And I'm sure you have a lot of these conversations too, where it's like, well, I want to sue him. It's like, okay, well, he's going to sue you back. And then you're going to be trapped in a lawsuit because now he's suing you. Is that something you want to be stuck in? And then at that point, we have less control over what it's going to cost. And so there's certain just certain situations where you're crossing a bridge, you're crossing the Rubicon, and better be ready to fight. How do you counsel clients in those situations where you understand that, okay, yeah, the demand letter, you're talking maybe hundreds of dollars, okay, and at some point you're like, okay, it's time to escalate. Understand what you're getting yourself into. Can you talk a little bit about that?
Sure. So I understand that there are a lot of litigators out there who, their whole point is of even sending a demand letter is to get to litigation. I don't think that's always, or that should ever really be the case, right? There is a finesse to it to where you can assert your rights and you can let the other side know what is the problem with their case, right? So that they don't think it's a foregone conclusion that they will win. Absolutely. If they file suit, right? Let them know their own exposure, their own risk at that stage in time. But the only way you can do that is if when you send out letters, demand letters or whatever, you have to do it in a way that's a little bit like you are assertive with regards to the facts, but you're not doing it in a way that's inflammatory. A lot of these demand letters do come off as like, hey, screw you. And then the other side goes, oh, no, screw you, right? Like it just comes back and forth. And it goes straight to litigation after that. But you don't have to do that. And I think a lot of times it's on the part of the litigator who's not as close to the situation, may not feel as strongly about it from a personal perspective, even though they may feel strongly in terms of the merits of the case, to go and kind of finesse that language out. Because what's going to happen is they're going to take it to their attorney. And if it is inflammatory, their attorney is going to then advise their client, oh, no, there's nothing here. Let's just go to war, right? But if you can do it in a way that's kind of a little more nuanced, right? Their own attorney is going to be able to see the risk and then take that to their client. And if they don't, they're not being a very good counsel.
So I want to ask you a question on that because you brought up something very, very interesting. Everybody that wants to go on the offensive wants to hire the most aggressive litigator they can because they want to stick it to the other guy. Having said that, if you go down this path and you hire yourself a litigator that's very aggressive, that enjoys going to court, doesn't like anything else, but they just want to go to court all day, that might not be in the best interest of this business owner. Because, hey, you want to get a settlement here, or you want to get a resolution rather at the, with spending as little amount of money and getting the max that you want without going through these perils of this litigation, getting caught up in this lawsuit. So how does a person looking at hiring a litigator who's really emotional right now, right? They just want to chop the other guy's head off. How do they prevent themselves from falling into that trap if they go straight to the litigator? Do they need to go to their transactional attorney? Do they need to go to somebody else to say, hey, hold on a second there. Let's slow this down. It's a very delicate balancing game here. How would somebody go about making sure that they're not picking the wrong person, that the litigator that they picked is a good fit for them?
Yeah, that's a very tough question, because people don't know litigators, right? Like they don't, like, it's not a common thing, right? Maybe they see someone on TV and they think that's what a litigator is supposed to be, right? I don't think that kind of personality is necessarily all that common in commercial litigation. It may be more common in like personal injury cases where you're just like, oh, look what happened to my client. It's so terrible. And you just grow, right? But, commercial litigation is complex. You have to deal with these issues, because a lot of times it doesn't even go to a judge or jury. It goes to like summary judgment, right? Because these are contract issues that have law behind them, and you can use that law to kind of to end the case prematurely before you even get the trial. But yeah, I think being aggressive and being inflammatory are two very different things, right? Being aggressive is being on top of your game, filing the motions that you need to file. Do not miss your deadlines. Continue putting pressure on. Don't wait on your rights, so to speak, right? And yeah, I think you can you can kind of walk that line. But as opposed to, or with regards to your question about how you find that person, a lot of times you just kind of have to trust the people that you know. If you know someone who's an attorney, a lot of times they can give you a reference to someone. But yeah, I think a lot of times people choose, fortunately, the wrong attorneys. And I've had a lot of people come to me and ask me like, hey, should I hire this person because they have all these like fake awards on their website, yeah, it's hard to make that distinction between like what's real and what's just what's just fake, because there's a lot of attorneys out there who have big names are not very good.
Chopping someone's head off is not a remedy in court. Like as much as you may want it to be, no one's getting their head chopped off. So if you're going to see your attorney and if you can go into that mindset, you're going to help your attorney be a better advocate for you. It's Lincoln's job and my job to kind of set expectations. But if your expectations are going in are something that's not even realistically available, you're not going to be happy with the outcome. Or you might have the budget or the wherewithal to say, I just want to put some misery through this other person. You could certainly do that, but what I found is after a couple months of doing that and paying a couple months of invoices, and all of a sudden you realize that you didn't really get the benefit of what you paid for. It didn't really make things better off for you, knowing that you tried to make someone feel miserable. Civil litigation or civil disputes, or even the stuff we write, ultimately it's generally a dollar and cents situation. We don't have the ability to put someone in jail. The government has that ability. So you have to understand, I try to counsel clients on this as I transition them over to Lincoln, is this is an investment that's in somewhat. You're trying to get a return on investment. Now, some of it may be to get somebody, the return is we're getting somebody to stop what they're doing. So it's not necessarily a financial return, but if you're going to spend $50,000 or $100,000 on something, and all your damages are worth or $10,000 or $15,000, well, that doesn't make any sense anymore. So you have to, just like our clients or business owners, think about how they're going to make money on a certain investment. when they come to us, I always counsel them to think of us as in the same way. You're investing in us to go get an outcome. Is the return even possible? And experienced lawyers like Lincoln and I, we can help you assess that before you start. And I think good lawyers do that. They help their clients assess what the potential outcomes are and if it's going to be a good return on their time and money.
Yeah.
Right. I absolutely agree with that. And I think, and a lot of times it's not going to be just like, it's going to take all this money to go to trial, right? Like people always think trial, but sometimes it's a solution that may end quickly, like a summary judgment, right? You can get a summary judgment quickly if you think you have the rights to do that, right? Like a suit on sworn account or something like that. But yeah, I absolutely agree. You have to be able to assess the risk and assess the cost of litigation. And a lot of times litigation is very expensive, right? And a lot of times litigation can outweigh the benefits of what you could potentially earn. And it's on top of the risk, the potential risk, right? But I think there are situations, and I have seen that, right, where clients they just want to make the other side hurt, right? I think that is obviously the wrong motive to go to litigation. But there are instances where, especially if you're in like a novel industry, where it's a matter of principle and you don't want to set a bad precedent for the future, especially if it's someone you do a lot of business with. Just, you don't want to let them step on you because they'll do it again. They'll keep doing it until you stop them.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.